Hi, everyone. Welcome to today's LawWorks Legal Primer webinar, My First Job, jointly organized by Law Society Pro Bono Services and the National Trades Union Congress, NTUC for short. I am Regana, your moderator for today. So before we start, a couple of housekeeping matters. Please feel free to ask any questions at any time during the webinar using the Q&A icon at the bottom of your screen. We will do our best to address your questions during or at the end of the talk. There will be a resource link shared in the chat function, my apologies. The link will also be sent to you in a follow-up email tomorrow. Now, please note the discussion and any material provided in this webinar is not intended to substitute or constitute as professional advice. You should always consult a lawyer if you require specific legal advice. Now, with that, our panelists for today are Toh Wei Yi and Patrick Tay. Now, Patrick, could I get your cameras on, Wei Yi and Patrick? Patrick is the Assistant Secretary General of NTUC and the Director of NTUC's Legal Services and Strategy Division. Wei Yi is a partner in the Litigation and Dispute Management Practice Group at Harry Elias Partnerships. Thank you both for joining us today. Now, you have graduated, you have decided to come out of retirement, or you plan for a mid-career switch. Whatever the situation is, all of a sudden, life is no longer about exams, hanging out, having coffee, having lunches, or hanging out at the pantry of your office, okay? In an instant, it becomes a journey of selling yourself to companies and hoping for someone to offer you that dream job. Then suddenly you're gainfully employed after signing on the dotted line. But often your first or your new path job is your pathway to the working world and is the first relationship you have outside of your family and friends. Now, first jobs are critical because whatever choices you make in your first few months may and will define the rest of your career and journey. So sometimes things don't go the way you plan. You know, Wei and Patrick, I'm sure we'll be discussing a lot of this during this webinar. So the objective of today's webinar is to share real life challenges of how you may encounter as you begin or restart your career and tips on how you may handle them better. So I have the two best panelists I know personally, and it's so great to have you guys. So let's start with their first career. So Wei and Patrick, very important question. How was it like starting and being in your first job? So let's start with Wei. What was your full-time job? Can remember or not?
Took me a while. Thanks, Regana, and thank you everyone for attending the webinar tonight. Okay, so my first full-time job was actually a job that I took during the long school holidays in college. I was a retail sales assistant. So it's a short-term job, but it was full-time for the period that I was on the job. I don't know, I just recall that it was an enjoyable experience, but actually at the beginning of it was quite daunting. So I don't even remember whether I had an employment contract. I think I had a half-page letter with my per hour pay, and that was it. You know, did not know what a contract really was. It was daunting. I didn't know anybody there, whereas all the other colleagues had been there for a long time. So I would say I kept my head down and I just observed as much as I could. And I think that helped. Yeah. And well, slowly you just get used to it, and then you start thinking about doing better on the job rather than to just survive the job, you know?
Yeah, and thank you very much for sharing. How about you, Patrick? What was your first job like?
Hi, good evening, everyone. And interestingly, also in the retail sector, I remember after my A-levels, I was like waiting to go to national service, and we had like a 3 months break in between. So I took up a job as a store assistant, I recall very vividly, at one of our NTUC fair price outlets. Yeah, I'm still with them after so many years.
It's fated.
Yes.
And it was actually at one of the stores near where I live in Bedok. And because it was near the Chinese New Year, Christmas period, and they really need people, so I kind of like worked full time there for 2 months. So like to keep fit, at the same time also prepare for national service and make some pocket money. And like Wei Yi, it was a very first job, so I didn't really look through my employment contract. It was just 2 pieces of paper with a fair price letterhead telling me, my hours of work, how much I paid, and some of the benefits and stuff like that, and then issued 2 nice fair price t-shirts, and I had to wear that for work. So that was my first encounter in a kind of like a full-time job.
Well, I'm impressed you have contracts. When I did mine was in F&B, it was just a handshake. You can put sandwiches together, okay, go and work now. It was that easy, So, but thank you very much for sharing that experience. So let's get down to it now. Research shows that 17% of employees leave within the first 3 months, which is a typical duration of a new hire probationary period. Now, sometimes it's 3 months, sometimes it's 6 months, depending on the company. Starting a new job can be really a nerve-wracking experience. I remember my first full-time one and I was so nervous. So the journey can be bumpy. So together with our panel today, let's look at some of the common challenges you, our audience, would face when you're starting your career or jumping back into one. So let's look at the first challenge, reality versus expectation. Okay, realizing that it's not your dream job after the signing contract, but let's talk about before signing the contract. So Wei, before someone signs a contract, what are some of the key employment terms one should look out for before committing?
Well, actually, a lot of it is quite instinctive for a job seeker. Pay, what's the CPF, what's your take home, do understand that there needs to be the contribution for CPF. Overtime, do you have overtime pay? Job scope, what is your job scope? And can your boss redeploy you? I think that's something you should consider. Your leave entitlement, termination. I think a lot of people don't think about termination when they first start on a job, so kind of like, bad omen, but you do need to look at it. Your notice period, for example, in termination, is there a difference if you are on probation still? And I would say maybe your hours of work and maybe venue of work, because right now there's this whole promotion of the flexi work arrangement. So possibility of working from home, if you're hoping for that possibility, then I think that should be spoken about upfront.
Okay, so in the event that they have any hybrid situations or they're expected to be in the office full time.
Yeah, some people may have the expectation of a hybrid arrangement, now that it's quite prevalent, but I think it should always be made clear and spoken about.
Thank you very much, Ray. How about you, Patrick? Anything besides legal that one should look out for before signing a contract?
Yeah, so Wei Yi pointed out some of the key employment terms we need to look out for. Of course, statutorily, there's the Employment Act that governs employment relationships, and when you sign an employment contract, when you're an employee, between you and the employer, there is a contractual agreement, and therefore, in Singapore, we have the Employment Act, which governs some of the key areas, from hours of work, and various areas, particularly in situations when things are not too spelled out too clearly in employment contract. This piece of statute actually helps to plug some of the gaps. Over and above that, actually, interestingly, a couple of years ago, we came up with a deck of tripartite standards, which we'll try to put up the link on the chat. Tripartite standards on key employment terms, and that basically sets out some of the key employment terms, which we hope employers out there, some of you employers or HR leads, will turn to use as sort of like a key areas which you need to state in explicit and clear terms in a way to minimize doubts. So on that note, those are some of the areas which you can look at. And at the same time, also, if you are not too familiar, we actually, as part of this LawWorks legal primer plus our this collaboration, we have done up a pocket series, my first job. We came up with a very, very simple, handy guide, which we will try to give you a link via the chat as well, so that you can access that. And it provides a checklist of some of the things, the key employment areas, terms and conditions, which we hope as a first-time employee or first-time job seeker, or can turn to make sure that at least these basic grounds are covered.
Thank you very much, Patrick. And yes, we have just dropped the resource link in the chat. So participants, please click on the link and download all the great resources that LSPBS has put together with NTUC. So the next question, which I have been guilty about, is what happens if a person signs up of a job offer, company A, and then suddenly, because when we're first job, we go for so many interviews, then company B comes and says, I've got this job offer, better pay, better everything. Wei Yi, any legal implications if someone, or let's say for example, me, rejects the company A? I've already signed the contract. I'll go back to them and say, okay, so sorry, I want to go to the other company, I got a better offer. Any legal implications?
Very much so. And I mean, I would say sometimes it's very difficult for the job seeker because, sometimes there's pressure from the employer. Actually, I personally have been put in a situation where there's been some pressure to sign as soon as possible. And I just really had to do my best to hold off and just buy time. And I think in the end, thankfully, I did do that and I made the right decision eventually. So I think certainly this is a pressure that new job seekers will face. Yeah. The unfortunate truth, though, is that if you sign on the contract and it says, for example, you sign a certain date and it says that your commencement date will be, a week later or some days later, that is already a contract that you have signed with the employer, that you would work with the employer. So very strictly speaking, if you were to decide not to commence your work with the employer, you would generally have to submit a resignation proper, and you would have to serve out the notice period, or you would have to make the payment in lieu of the notice period. So that's the unfortunate reality. I would say, though, that if you are ever put in that situation, just try to speak with your employer. The employer, of course, has the discretion to waive all these notice period and whatnot. And sometimes unexpectedly, you may have, someone who's, a little bit more generous, and it could still work out. So do just speak with the employer, even though, strictly speaking, the employer can insist on the notice period or the payment in lieu.
Yeah, so Wei Yi is quite right. We do have situations, and I've seen situations or advised situations such as this, where, especially these days when it's a quite employees market, and you do get a couple of offers. So on the part of an employee to be, I think it's good practice, particularly, particularly if you are in certain more niche industries. It's a small fraternity, so be kind to your prospective employers as well. And more importantly, to make a concerted decision, even if it's a situation where you do sign a dotted line, and of course pending another offer. So find some way to to buy more time before you already sign a dotted line. And as Wei Yi mentioned, unfortunately, in most cases, employers are usually quite compassionate. They don't really penalize, particularly if you have not started work. But they have those rights, unfortunately, or should I say the legal right to pursue an action against you to recover whatever notice pay that you're supposed to give in lieu, or I hope not force you to work. But so that's one scenario. The other scenario, of course, for the employee, try your best where possible to, as a practical advice, to consider all the various options, and even if you are going with this particular employer, and if you have pending another offer that's going to be announced in the next couple of days or weeks, do apprise the HR person who is working or dealing with you. I think this kind gesture and also a sense of professionalism, because particularly in certain sectors where it's quite niche and the fraternity is quite small, what does go around. So it's good to to hold yourself to high standards and be professional about it.
Yeah, great advice, Wei Yi and Patrick. Really, don't be pressured, and also inform the employer who has offered you, and you have something in your bag, another interview or another potential offer. I think it's just being polite and courteous lah. Okay, so the next one is unknown environment and new culture. It can be very daunting, new places, new faces. Everything is new, especially when you're starting your first job. So this is not so much of a legal, but how does one manage oneself in a new environment of corporate culture? So maybe I'll start with Patrick first. Patrick, your advice to someone who has just started their first job or making that job switch after a very long sabbatical, how can one not tackle the problem, but sort of work together in that culture and environment?
Yeah, I think I'll give 3 short tips. Firstly, find out about the company. Yeah, I'm sure now with the World Wide Web, you can actually get quite a lot of information, and through various networks, industry networks and associations as well. You should be able to get a good understanding of the company culture, some of its history, what's its key focus, trust, and objectives, and various areas that they are embarking on. So knowing the company is one good thing. That you can even do even before you step inside. I'm sure some of you do it before the interviews as well, because sometimes employers or HR do ask prospective employees that about the company and what do you think about the company in the course of the interview. Besides that, it's useful. I know most companies do induction programs, especially those with more established or more structured HR practices, do induction programs for their new hires. Particularly important, as you know, in the last 2 years, many of the new hires were meeting each other, even interview online, and never seen each other face to face. So that's one big challenge that many of us have and face. So it's important again to have some form of induction orientation. So if you don't get it, or the company doesn't have such structures, it's good practice to catch up with the hiring person, the hiring manager, or the HR department, or the HR person or the hirer to find out more, to orientate and get him or her to, or that buddy or that supervisor to bring it around to meet people. Like I said, it all depends on the size of the company. It could be a startup, it could be a small and medium enterprise, it could be a large enterprise. So it varies. Yeah, but otherwise, good to know the shop floor, the factory, the people around, and of course the company. And the third thing, very, very important, is a good resource you can go to is the HR manuals and guidelines, because actually even before you sign on the dotted line, preferably to have read them as well, because that encapsulates quite a lot of the day-to-day procedures, etc., and the roles and duties of both employer and yourself as an employee.
Great. How about you, Wei? Any tips or any advice on someone coming into this new environment?
Well, I would say on the legal aspect, I completely agree with Patrick on the company handbook or the internal policies. I think some of you may realize that if you join a large company, in fact, they will incorporate the employee's handbook or their internal policies as part of your employment contract. So in a way, it becomes one of your employment contractual terms. So it is quite important for a new hire to have a look at this. And I mean, for the very practical reason that at least you don't step on toes, by doing things the wrong way in terms of the company's procedure. I think on a more non-legal aspect, what I think is actually very useful is to find one ally, find one co-worker. It could be like the person who was the most recent new hire before yourself. And just having that one person, I mean, it may not be possible to make friends with everybody, so quickly, but just at least find one ally. Understand from that person what the company culture is like. Understand your boss, what your boss is like. I think it's, and I mean, of course, I would expect you try to pick somebody who's quite helpful. So I think you could get a lot of insight through this channel. And I suppose now that gatherings are starting, like maybe social activities are starting, do try to include yourself, even if you may have something else to do, or that there might be some time pressure, but just do try to include yourself. I think it's a good way of learning about the company culture.
Yeah, actually,
colleagues.
That is a really good advice. Finding a buddy, and if the company, if it's big enough, they usually have like this mentorship system, buddy system that you can tag along.
Yeah.
That's really great. Okay, challenge number 3, unpaid OT, which I know happens sometimes quite a bit, especially during this COVID. People work from home, you can't tell here and there. So working day hours and the company does not pay for OT and not even time off. So I'm going to ask Patrick this. What can a new joiner do to manage this? Can they join the union?
Yeah, of course, I will tell everyone here who is online, if do be a union member at the very least. Yeah, otherwise, not all companies in Singapore are unionized and have a collective agreement. So if you have fair and well, go to your union leaders, go to your union representatives, industrial relations officers to get help if you really get your OT unpaid. But more importantly, as a general piece of advice, also important to see whether you're entitled to overtime, because certain categories of workers are not entitled to overtime. I won't go into the very detailed specifics, but it's actually prescribed in the Employment Act of Singapore in Part 4, which is actually, incidentally, the heading is called Hours of Work. So only if you are Part 4 employee, so to speak, that you'll be entitled to overtime payments. And there's a formula there and how it's being calculated. However, in most instances, particularly managers and executives, like many of the white-collar employees, most, if I may say, do not get overtime payments. So do take note. However, there are also some situations, some employment contracts, including some collective agreements in unionized companies where although in those situations where some executives may not be entitled to overtime payments, they do provide shift allowances and overtime allowances, sort of like to compensate and to incentivize those who maybe do the graveyard shift or do an extra work, particularly when during rest days, etc. So do take note of all these pieces of advice. Like I said, it's quite a, you probably need a entire session on the Employment Act to understand how overtime is paid, but good as first principles to see whether you're entitled to it, and if you're entitled to it, whether you're paid accurately. I think all these are accessible materials via the links, as well as the Pocket series, as well as many of our NTUC, as well as Ministry of Manpower web pages. They are all quite explicitly stated, and even some of the calculations and the formulas are all there. So very, very easily accessible. I mean, these days it's virtually very, very, very easily accessible, all these useful information. Finally, if you qualify for overtime and if you are already not paid overtime, do speak, of course, first principles. Do speak to your HR, your supervisor. If you're a unionized company, speak to your union leaders, their unions. Otherwise, if you're not in a unionized company, not a union member, you can also go to the Tripartite Alliance for Disputes Management, which can help, particularly in situations such as this, where there's unpaid overtime situations.
Okay, thank you very much, Patrick. So Wei, I'm actually going to jump into challenge number 4, toxic environment. But there's a question actually that's come in based on this. So I'm going to actually ask the question. Someone actually asked for an internal transfer to another branch. Let's call it branch B, and the director at the branch A, where the person wants to transfer out, keeps telling him or her that he is like friends with the director at branch B and will make the other director make his life difficult for that person. So basically quite a toxic environment. Sounds like a really toxic environment. What can this person do? Anything legal, or what would your advice be?
Well, I mean, this depends very much on how the company is structured, how the management is structured. So clearly right here, now the problem is with the direct boss. So I suppose, telling him to speak to the direct boss is not going to work. The question is this company's management with a hierarchy such that there's somebody whom he can approach who is superior to his direct boss and to highlight the problem? I mean, I think workplaces, employers, they don't want to escalate these problems and make it so public. So I think, he or she can count on a bit of discretion or rather the person he speaks to be a bit more discreet about the situation. And I mean, ultimately, if, for example, where he is now, it really is not working out. I think if I were him, I would take the chance and transfer and speak with the boss at the new branch. I suppose that's another solution if you don't see anybody high up in the hierarchy who you can speak to. Unfortunately, I think the truth is that if even after redeployment, it doesn't work out, then the only practical solution would actually just be to leave the company. I mean, the truth is that you can't change your work environment, you can't change the colleagues around you, and I don't suppose you could replace your boss. So it's a very practical piece of advice. Might sound a bit unfortunate, but I think that's the reality of it.
Yeah.
But do try to speak to somebody. I always think that it's worth trying this approach first. And if it really doesn't work out, no skin off your back, right? Then you decide whether you want to leave the job or not.
Great advice. Patrick, anything to add for our participants who asked this question?
Yeah, I think important because it's just a remark made by that director. I thought important if it really like what we mentioned. This is just a remark. That doesn't mean anything until it's until your life really becomes difficult. Yeah, because it's just a remark. So I think they should go. He or she should go ahead. And if things does materialize or whatever that was threatened does materialize, I think go to HR or go to your union leaders that are on site, and if you have been aggrieved or been a victim of whatever scenario, some discrimination of sorts. Yeah.
Okay, thank you very much. So the next challenge is, and I see it every day, people not asking questions. Everywhere they don't ask, right? Because especially when you're a fresh person on the job and they've got this thing of, oh my God, I don't want to ask a question because I look silly and things like that. So I'm going to ask, wait, what's your advice to a new joiner? Just one advice. Ask a question. What's your advice?
I mean, I was definitely guilty of that for my first job. I thought perhaps safer to keep my head down, not ask too many questions and just try to observe. But I would say that sometimes not asking also doesn't really help matters. Obviously, it's a situation where you've tried to observe and you can't find the answer. What I would do is, I think before I speak to a senior or ask the question for a solution to the problem, I would try my best to find a solution first. I'll make efforts to try to source out a solution. If I really can't find it, then I'll go to the senior and say, look, I've got this problem. I don't have a solution. I've tried looking, A, B, C, D, but I still can't find. Do you think you can help me? I think it always sits a lot better with your senior to show that you've tried, but of course, perhaps, due to inexperience on the job, you can't find the answer. So that's what I would offer.
My tip is just ask the questions.
It's the easiest.
Patrick,
I think these days, employers are looking out for people with an inquisitive mind, wanting to learn, wanting to find out. So by asking questions, I know most of us, worry about the face thingy, that do I be embarrassed? Will I be asking stupid questions? But I think more importantly, by asking questions, you show that you're interested, you're engaged. At the same time, also that you're willing to learn and find out more. Particularly in areas where you're not too sure. So I think it's good, but it depends on the platform, whether it's in a meeting context or in the office space, or you're being asked to do certain new area or project and you're not sure. So asking questions may not be a situation where you always ask the boss, but it could be co-workers, it could be even subordinates sometimes. And of course, different project leads, for example, but particularly in the matrix organization.
Yeah, I think it doesn't matter how old you are, I still ask questions. Well, all like this, still asking questions. So the next challenge is workplace bullying and harassment. And I'm going to actually ask a question for Wei Yi, because someone's written in that he or she has a female colleague who's experiencing harassment from an older male colleague who keeps staring and teasing, quite unfortunate, staring and teasing at her, and she's very uncomfortable, but doesn't dare raise up to HR. I'm assuming either she's quite afraid this person could be quite senior. What can she do? Is there something that you could advise?
Well, I mean, there are always these legal avenues. Everybody's heard of POHA, protection from harassment. If it gets to such a level, then, that's always an option. But I mean, let's just address it before it gets there, I suppose. If it escalates to that situation, I think it might be very difficult for this employee to continue in the workplace. So I think to address it within the workplace, I mean, instead of speaking with HR, can she speak with her direct superior? I mean, assuming this person is not her superior, the perpetrator is not her superior. But if he is not, okay, to speak to a superior about it, I think somebody who's part of the management will have more power to provide a solution rather than HR. Sometimes it depends. Some companies, the HR can be very involved. I guess some big companies, they have grievance handling procedures to handle workplace grievances. I think that's becoming increasingly common. So she should consider also engaging this procedure. That usually there's some level of confidentiality involved if indeed there is a grievance handling procedure. So I mean, I suppose she doesn't want to, publicize this problem. So yeah, if the company has such a process, she can activate the process. But if it doesn't have, I would suggest, if she can, to speak to somebody in the management, somebody who possibly can put a stop to it. I think she can probably also trust the management to be discreet about it. Usually that would be the case. Yeah.
I would really encourage, I know some of you are from HR or employers out there. I think it's useful to have proper grievance procedures as well as whistleblowing procedures, but particularly in this space, it's important because if you don't have one, don't worry. There's actually a tripartite advisory on managing workplace harassment. So you can actually download that off the MOM website, and you can Google and download it. And it's useful reference where it gives you a checklist. It's a tripartite advisory, not law, but it gives you some key areas as an employer, as a HR, or even as a line supervisor, what to look out for, and some of the procedures and steps to put in place so that your employees feel safe and secure in the workplace. Like you mentioned, of course, we try to resolve things at the lowest level, and so that the relationship between the employer and employee doesn't, or in fact with the supervisor or boss, doesn't become acrimonious. However, worst case scenario, particularly in more egregious cases, we have now the Prevention of Harassment Act, as well as the POHA Court as well, that's been set up this year. And this piece of legislation, which you can access, all of us can access, even for workplace harassment, where you can take some form of action. Previously, it would cost you a bomb because you had to hire people like Wei Yi to do it. But now you can go through the POHA court and or through the POHA procedure at state courts to stop the offending action or harassment, and of course deal with the perpetrator.
Thank you very much. So the next question, the next challenge, and it's a very real challenge, is burnout. Considering the last 2 years, lots of us are working from home, no day, no night. Finally, it's getting a little bit better now. So burnout is real, especially when you're a young person in the role, or a person who's just come back after a long sabbatical. You got a lot to prove. Patrick and Wei, any of you can start first. Like, how can anyone manage this? Is there anything that you can advise? Maybe Wei, I start with you first.
Well, actually, for me, I have been working from home, so I think this is a very real scenario. I think what has helped for me is to give yourself a routine, even if you're at home. Imagine you're at work, have a time routine, have a proper lunch break, have a 10-minute breather. I mean, let's be honest, even when you were all in the office, you would take 5 minutes out just to, I don't know, sit there and stone for 5 minutes or something, just to, give your mind a break, and I think sometimes when you work from home, people forget that, hey, you're entitled to also just tune out just for 10 minutes, just to give yourself a break. This next thing that I thought of, I suppose, and some friends have told me, I mean, provided that it's not a situation where it's just this overwhelming amount of work that you just simply physically cannot finish. If that's not the case, I think it has helped some people to pick up a hobby okay, like that requires, maybe an exercise class that's once a week. I think sometimes you just keep on working because you have nothing else that requires your attention. I feel so. Maybe if you have that something to take your mind off it, then there's kind of like there's an enforced breather as well. Yeah.
What do you do now for taking that time out?
I have kids, so
Yeah.
enough said. So I have to take the time out whether I like it or not. So, but exercise. Other than that, for my self-exercise. Yeah.
Great. Patrick, how about you?
Yeah, I think burnout is a really a clear and present problem. In the last 2 years, we have seen many of us work from home, hybrid arrangements, frontline workers having to fully don personal protective equipment. And so this issue of burnout is really real. We've seen more and more cases of people being more depressed, having mental stress, and sometimes even neighborly disputes happen because you're working from home, and now you hear your neighbors more than ever. So I think burnout is real, and even myself, I get burnout. Being on Zoom day in, day out, can be 7-8 hours at a stretch, and back-to-back meetings cut by probably a few seconds of Zoom time. So I think it's real. So I think it's important to be able to do few things like to dichotomize between work time and real personal time and rest time. So I think it's not easy. It's easier said than done because there's a temptation, particularly with our laptops, our tablets, and our devices all with us at all times. So I think it's a big challenge. I face that challenge too. So I think it's important to be able to dissect this. And of course, we have been talking about it, the right to disconnect. So if there are any employers out there or bosses out there, try not to send messages or reply to stuff that your employees send you, or send them mails in the middle of the night and stuff like that. So I think it's a whole societal thing. I think everybody has to look out for one another, particularly in this period of time as we try to transit back to the next normal. I think important to look out for one another and to make sure that we don't burn out, because it's real, and we are seeing it as well.
So Patrick, what do you do to keep sane?
Like we, I mean, I have 3 kids, so but more importantly is to exercise. Find some way to chill out in outdoors now that you can mask yourself outdoors, and do some form of exercise, something that's not too over strenuous, and something which you're comfortable with, and you can do it quite quickly and easily.
Keep some plants.
Mine all died, by the way. So
oh dear, you can find yourself another one.
Yes.
Another hobby then.
Well, thank you very much both for going through all these challenges and this real life issues and help. This is great. So before we jump into the first job seeker scenario, I have a great question. I'm going to open it up to maybe Patrick first. What are the rights of students on internship? Are they entitled for leave of days? Are they expected to work 5 days a week, 6 days a week, or OT? So Patrick, I start with you first.
Yes, so there are 2 scenarios. Well, internships are there are various scenarios. So I would like to address 2 different scenarios. One where it's like my case. After school, I before I start national service, I go take a 2-month job, and that's a formal employment contract. And there's a formal employment contract. So everything, the statutory provisions, statutory benefits, and everything else that we talked about earlier are sort of quite protected and guarded and provided. However, in some internships, like for example, if you are in mostly in secondary school, ITE, poly, or even in college, and even in universities, there are internships that actually MOE actually sets out some guidelines. So you don't actually get the full employment rights. You don't get CPF and stuff like that. Not that everyone doesn't get it. I know some employers do things very progressively, even though they are not required to do it by law. They actually do it out of goodwill, to so-called incentivize the intern. So take note. MOE, in fact, I recall bringing this up in Parliament something like a couple of years back when there was an intern who was being abused or slapped at. I think there was a viral video that went around. So actually, interns take note that well, things like the Prevention of Harassment Act and stuff like that do apply to you as well if you do get harassed or get sexually harassed, for example. So some of these statutory provisions actually apply to you. However, you may or may not get the full fledged Employment Act protection if it's a pure internship arrangements. So usually in most internships, there's actually a deck of documents which you will get assigned, and you can find out more from the school or from the institution or the Institute of Higher Learning which offered you the internship, and find out from them, because they do have some clear guidelines and of course clear provisions to say what in the course of this internship, what you are entitled and what you are not entitled. So do read them carefully.
Thanks, Patrick. Anything to add on, Wei?
Not much, just to say that it's fairly fluid. Okay, like Patrick said, there's so many scenarios. Actually, sometimes a lot of it depends on what terms are offered to you by the company giving the internship. Like for law firms, we offer internships very, very often
Yes.
for law students or even students who are not even in college yet. So I think what is common is that you probably won't expect the full suite of benefits that an employee will get, like maybe leave or whatnot. But I mean, basic things like sick leave and whatnot, you can expect to have. So do read that document carefully, because that document actually does govern the relationship with the company, or just call them employer to simplify things. It actually does govern the relationship, even if you are not a full-fledged employee.
Yeah, very, very important actually is to read the contract before you sign. And I think a lot of us don't do it, but very good advice.
And I mean, do ask some questions if you have any doubts. I mean, of course, people can choose not to answer you, but there's no harm in trying, right? So just ask. Yeah.
True. So actually, one very quick question, and I'm sure, Patrick, this is for you. How does one check or know if a prospective company is a unionized company?
Yeah, I actually tried to reply to that our attendee who had asked the question. Just call NTUC. We have a hotline. Call us or drop us an email, and we'll let you know. We don't actually flash out this information publicly, but if you want to check, like particularly if you have you may end up in or your prospective employer, or you might end up in an employment dispute situation, call us to do a check. We also have NTUC colleagues at TADM, Tripartite Alliance for Dispute Management, so they can also be another resource point to check whether your company is unionized or not.
Okay, thank you very much. Thank you everyone for sending in your questions. We will try to get to them, but don't forget to download the useful information and keep your questions coming. So let's start with our first job seeker, Siva. Now, everyone, you're going to be able to see Siva's bio on your screen right now. He's got a degree in mechanical engineering, very quickly just got a job offer as a mechanical engineer with a US company based in Singapore. So you can look at his job responsibility, great pay. So Siva just got offered this position as a mechanical engineer with a US company based in Asia, running his Asia's operations in Singapore. So now Siva is eagerly waiting to sign the contract with this company as is his first job. Now, seeing how is his first job, Wei and Patrick, let's guide Siva through this. Let's start with Wei. You shared earlier some of the key employment terms. So is there anything specific Siva should look out for, considering it's an international company based in Singapore?
Yeah, so the key terms that I spoke about, I mean, they are still important. I suppose what stands out for this scenario for Siva is that his employer is not really a local company. So I think he has to ascertain who exactly his employer is. Is it actually the US company? Does it even have a registered place of business in Singapore? Is it a subsidiary of the US company, or is it a US company with an office registered in Singapore? So there are actually a lot of legal permutations with it for this, because whether or not this employer is based in Singapore or is a Singaporean company may affect the type of legal recourse that is open to him in the event that he's got a dispute with his employer. So I think that's something that stands out for this scenario.
So if the governing law of the employment contract, I mean, let's say he asked someone and the governing law of the employment contract terms are US law, what can Siva do to make sure that he's protected locally? Or is there anything that he can do?
I think just because it's governed by US law, and I think this one maybe Patrick could jump into to give his view, just because it is governed by US law does not mean that it does not have to abide by some of the Singapore labor laws. Am I right, Patrick?
Yeah, that's right. So in most instances, in this area, employment law, usually the jurisdiction of the country where you deliver your services and you do your work, the laws of that particular jurisdiction will apply to you. So in some instances like this, where it's could be you be delivering your services here in Singapore, but it could be your employment contract may say US law governing it or some global HR policy. So you will probably have to deconflict both. But otherwise, if you are physically in Singapore, the Employment Act still applies to you. You can't exclude Employment Act or exempt or exclude the statutory provisions altogether. However, the key employment terms, please read the fine print, as what Wei Yi mentioned earlier. Very, very important. The fine print, particularly in this scenario, is very important because I've been involved in quite a few of these disputes before, where some of the US companies actually have some form of benefits, including severance packages, retention benefits, which are according to corporate HQ in the US. So in Singapore, depending on whether you have a collective agreement or not, that will provide for it. But otherwise, in some of these companies which are not unionized, and they may have US terms or be governed by US terms, you may actually have a right to recourse to some of these packages that are available globally for some of these multinationals. Yeah.
Okay. So let's say now Siva still hasn't signed the contract. Wait, one piece of advice for Siva that he should ask HR before signing the contract. Is there anything in particular he should be asking from a legal perspective?
I thought a few points are quite important. He's going in as a mechanical engineer, and looking at the nature of the company is quite global. So do check out, this as what we mentioned, the scope of work, yeah, and where he can be deployed, because you never know. And it sounds like a big company, and there may be many subsidiaries, so you can actually move across entities and stuff like that. So it's important to read the fine print. Otherwise, today you're in Singapore, you may be required or transferred to another jurisdiction or another part of the world, which you are mentally and physically not prepared for. So it's important to find all these out early. And particularly in this situation, also another third important point is to take note that in many of these large multinationals, there's always matrix reporting, meaning not just know your boss that is physically in Singapore, who you report to, but you may be subject to, for example, the Asia Pac HQ or some global HQ which has oversight over this part of the world. So important to know who you're reporting to. You may be having to report to multiple bosses all at once.
Okay, thank you. So Wei Yi, anything to add on this?
I think, like what Patrick mentioned on it being an MNC. Now, if it's a very large multinational company, what we have seen is that sometimes different policies, global policies may or may not apply to the employees. Some companies have very complicated internal policies. Like, for example, there's one set for global except Asia. And then Asia is governed by a separate set of policies. And these policies are fairly important policies, even like grievance handling policies. Sometimes it is peculiar to different regions. So I think when Siva gets into the job, I think he needs to familiarize himself with all these aspects. On a maybe not so legal note, maybe even apart from permanent redeployment, as a very practical concern, he should check whether or not he's required to travel, whether he's required to travel very frequently for this job. I mean, some people may have certain family commitments that may not enable him to travel very frequently. So this might actually become a problem. I say this, since it seems to have Asian operations, so it could be elsewhere in the region. So yeah.
Okay, so I'm going to ask this question to Patrick before I have another question coming in. Is there a place he can go for help? So let's say Siva hasn't signed the contract, but he's bought some time and saying that give me some time before I sign, let me think about it. Is there somewhere he can go that he can ask for advice, like a career advisor or a legal clinic?
Yeah, there are various places. Of course, under this LawWorks partnership, we have we run a monthly legal clinic for our union members, particularly with LSPBS as well as NTUC. But if you are not union member, you can always access our various PBSO legal clinics across the island. But more importantly, I think in Singapore, we have established 2 career centers. Firstly, the Workforce Singapore Careers Connect. There's an online platform, and there's also a physical setup. Likewise, also the labor movement that started the Employment and Employability Institute, E2I for short, the other so-called Employment and Employability Center other than WSG, Careers Connect. So we have these 2 platforms as well as 2 sites or one-stop services you can access, and the services are free. There are employability coaches full-time there, and you can actually go there if you really have issues or wanting to find out, how before I jump into this sector, before I jump into the next job, some advice. So we do have full-time employability coaches at both platforms and places for you to access to.
And that's really great. So before we jump into the next job seeker, there are 2 really great questions. I'm going to ask this first one to Wei Yi. And I think, I don't know whether the trend is still happening. Can a potential employer insist on knowing your last drawn salary or asking for a payslip? Payslip, not so much, but they usually do ask about your last drawn on the form when you fill, at least during my time. So Wei Yi, how? Can they still ask or not?
No, people will try, but there's certainly no legal obligation on your part to reveal. You have no existing relationship with a potential employer. There's no legal relationship, and then there's no obligation on your part to reveal this. Now, I would say that it is commonly revealed when prospective potential employees, they negotiate their salary. Okay, so I think this is something that, because it happens pretty often, because it serves a certain function for the prospective employer to gauge where to place you on the salary scale. But truthfully, there's no obligation. So if they insist on it, and you must understand your rights, and you can choose not to reveal it.
Great. Patrick, anything to add on that?
Yeah, this was raised a few occasions in Parliament, as well as we had some tripartite discussions on this. We have not landed on a position, but otherwise, because it cuts it both ways. When you ask for last drawn, some employees or prospective employees may not want to reveal, not because they used to earn a lesser salary, but they may have earned a much higher salary, and are worried that when the prospective employer sees his last drawn, he or she may not want to hire him or her, because they felt like, oh, I'm probably underemploying you, by putting you in this new opening. So actually, it cuts both ways. There's no right answer. Of course, there are some who actually declare, on paper, maybe a much higher salary to get a better salary. But otherwise, there are actually a lot of indicators today, a lot of industry reports, salary benchmarks across different sectors. So that actually provides a good gauge. So I think as we move, as our society and the labor market matures and develops, I think the likely direction we go ahead, maybe setting up advisories to say that, if there's no need to ask for last drawn, we need not do it. I think today, employers are looking more at skills, experience, and how much they pay you would be actually quite, they have already done some getting up about the industry practice and the benchmarks.
Thank you. So actually, this is a question for Patrick first, because it says specifically for Patrick. Are you seeing a rise in cases or disputes between employees who prefer or might prefer working hybrid and employers who prefer their staff to go back how things were pre-pandemic? Example, everyone physically in the office, and now that we are moving towards a COVID endemic state. Are you seeing this trend where employees are disputes?
Yes, definitely there'll be a lot of questions being thrown, because now that we have tasted 2 years of the pandemic, we have seen that sometimes work from home totally is possible. Not for all, maybe perhaps the frontline staff can't do that. They probably have to rotate. But otherwise, those that can they can work from home or be flexible. Today, I think more employers are more enlightened, more willing, more open to do it, now that they have experienced it. So in more ways than one, our flexible work arrangement drive has gone on an overdrive, and in a way, we accelerated some of these best practices. However, you're right, there may be instances, of course, today, most employers are still watching what the multi-ministerial task force announces. Today, we are about 75% can go back to work. We're not 100% yet. So we have not reached that point of time where we need to discuss whether you're supposed to come back to office. I can make you come back to office. So we are still trying to work within this 75% rule. However, you're right. I know of workers who find that if the nature of the job can be totally flexible, and they can work from home, why are you stopping me? Particularly those with family care arrangements. It could be young children, it could be elderly parents or grandparents or relatives. So these are some of the more exacting challenges. However, do bear in mind, I also know of a big group of employees, particularly our new hires, who have not seen their supervisors, have not seen their co-workers for the last 2 years. So we also empathize with them, and many of them want to get together and get to see real faces. So I think it's important to have a mix. I think moving ahead, I foresee there'll be a likely more of a hybrid arrangements. As we all know, prior to COVID, all of us are hired to come back to office, unless there's some flexible work arrangements that's already built into your collective agreement or your employment contract. But otherwise, I think moving ahead, it'll likely be a hybrid arrangement. And I see the civil service adopting that, 2 days, 3 days compulsory back to work. I think more for company bonding, culture, and employee engagement, more than requiring actually you to come back physically for the sake of coming back physically. So I think we taking the right spirit. I think moving ahead, there will be a bit bigger drive or bigger acceptance of flexible work arrangements.
Okay, something to look forward to. So, Wei, there's a question for you. Someone's facing a constructive dismissal from his or her employer and has engaged management, union, and HR, but seems to be still going on. What are the legal protection against constructive dismissal and any options for recourse?
Well, I won't speak on the union side. I think Patrick would be much better placed to answer that. But in terms of constructive dismissal, it is something that it can be raised as a claim in court. Okay, it could be, and usually the sort of relief that you're looking at is probably what you would have received as notice pay for a normal dismissal. That means a dismissal that is without cause, okay, that the company has said, sorry, we're just terminating your employment. There's no like a no fault, somewhat like a no fault. So usually there is a notice period or payment in lieu of notice. So this is something that, however, usually has to be adjudicated in court. I can't remember off the top of my head whether or not this is something that may be dealt with by the Employment Claims Tribunal.
Possible. If we can kind of prove it as wrongful or unfair, you can bring it to TADM as well as by the ECT route. So that's another avenue.
Yeah. So provided, however, of course, that your claim amount needs to be below 20,000. There is a limit. And I think for unionized employees.
Yeah, 30,000.
30,000, right? So that's actually an avenue that is a lot easier, I think, for the employees, because in fact, legal representation is not allowed at the employment claims tribunal level. So I think this might be something for him or her to consider as a first recourse, rather than to try to commence a claim in court for this.
Yeah. And then for union members in a unionized environment, there's a provision in the Industrial Relations Act, Section 35, which allows the union to represent or to file action to the Ministry of Manpower after going through the whole conciliation and other routes. Yeah.
Okay, thank you. Can such legal disputes go through mediation?
Yes, I think for if you're specifically referring to constructive dismissal, whether it's through TADM, Tripartite Alliance for Disputes Management, as I mentioned earlier, if we are going through the Section 35 Industrial Relations Act route through the unions, both ways, if through the union, there's actually a conciliation or process at the Ministry of Manpower before it escalates and goes into the full-blown matter. Likewise, if you go to the ECT, there's a requirement that you do a triage at TADM, and there will be mediation in a way to help come to some compromise between both parties before the matter is being straight away heard by the ECT.
Thank you very much. There is a question which a participant really would like me to ask both of you, and I think it's more for Wei Yi. The boss of a company has asked an employee to sign on a dotted line to waive his rights to bonus payout in December 2021 when he transferred him from the sister company to the subsidiary. So okay. If not, the employer will ask him to leave the company. This threatening behavior has resulted in him signing against his wishes. So obviously he is signed to waive his bonus. So he has reported it to MOM. The boss has countered to say it's defamation. Is this considered a civil suit of defamation? It's a very interesting question.
Well, the thing is this: if what he says, whatever he has reported, okay, and I suppose reported to MOM is true, okay, and then I would say that he's got a perfectly good defense to any claim in defamation that the employer has. See, the thing about defamation is this: people will just sue for defamation on the smallest comment that is made. And I think the problem with this is that you can't stop people from taking that first step of suing. But the real question is whether or not you've got a good defense to what you have said. And if what you have said is true, and you have only told the people who need to know on a need-to-know basis, and if, for example, if he has made a report to MOM, it's not as if he's publicized it to the world at large. Then there's a good justification. I mean, in legal terms, we call it a defense of justification, that what he said is true, and therefore it is not defamation. And he's only told MOM. So I would say that if this employer tried to sue for defamation, it is unlikely that he will be successful. But the unfortunate reality, though, is that some people still try to sue, and then you would be dragged into the court case.
Long drawn court case, yeah.
Yeah.
Patrick, anything to add before we jump into our second job seeker? Nope. Okay, so let's jump in. I mean, it's been a great discussion. We've got 25 minutes left on this webinar, and I'm trying to take everyone's questions. There's some really, really great questions, but let's look at job seeker number 2. We're going straight into Ali now. Ali is 58 years old, was retrenched after 10 years. So the work scenario right now is he was recently retrenched from a company and which was going through a tough time, which many companies were scaling back staff. Ali's finding a lot of problems looking for a job. Okay, gone for many interviews, turned down many times, and Ali feels it could be his age because he's 4 years shy from the retirement age. So Patrick, what kind of support is out there for our older generation who are seeking employment?
Yes, important. Firstly, of course, if it's a union member and a unionized company, then we can act on his behalf. We can come to the union and speak to our union leaders and, of course, the labor movement to advise him on the course of action. However, if he's not, then from the brief facts, I hope he would have received some form of retrenchment payout. I said if it's a unionized environment, usually it's provided in the collective agreement. However, if it's not a unionized environment, then good to find out whether he has received any form of severance payment as according to the employment contract. Unfortunately, in Singapore, the Employment Act does not mandate a payment of retrenchment benefits. So it all depends on whether there was a collective agreement that's provided for it or an employment contract that provided for it. But however, there are some tripartite guidelines on managing excess manpower, which alludes to payment of some form of retrenchment benefits. Again, that's tripartite guidelines, so it depends on the circumstances of the case and the industry that he or she is in. More importantly, because he's 58 years old, and we're a bit concerned whether is it because of his age that he was retrenched or laid off. So if he had been discriminated against because of his age, because of ageism and ageist practice, then he can actually file a complaint to the Tripartite Alliance for Fair and Progressive Employment Practices, TAFEP for short. So TAFEP actually oversees areas of age discrimination, even in such instances where there's age discrimination on those who are being retrenched. So I think that's one avenue that Ali can go to, TAFEP.
Okay, so I've just heard from Patrick about the Retirement and Reemployment Act. Just very quickly for our older participants out there, what is it exactly?
Okay, so I have to caveat that there's some amendments to the Act. I think that will take effect middle of this year, right? Around the middle of this year. Yeah, so, okay, as it stands right now, okay, the minimum retirement age is 62, and there is an entitlement under the Act to be re-employed until you hit 67. I mean, of course, in practical situations where your employer is unable to re-employ, then what happens is that the employer may give a payout at the point of retirement. I think with the amendments in the Act, I think the age is now 65, 68, right? Retirement age is
yes. So
right?
so we are right. As of 1st July this year, retirement age should be raised from 62 to 63 with a view of raising it to 65 at some point of time in the near future, hopefully by 2030. And as you already pointed out, the re-employment age has also been raised as of 1st July this year from 67 to 68, and with a view of it reaching 70, hopefully in the years to come, maybe 2030.
Yeah. So for Ali, I mean, if he manages to get a job right now, then I think the new provisions, or rather the amendments, would take effect middle of this year, and then his retirement age will be 63. And if he has managed to work for this employer all the way until he turns 63, then he could be eligible for re-employment at that point in time.
Regana, you're muted.
You're on mute.
This is my first time being on mute. It's terrible. So my question is, is there a specific criteria for an older employee to be eligible for re-employment? Is it, Patrick,
Yeah, there's just some simple criteria. Basically, it's for re-employment, his work performance has been satisfactory. I repeat the word satisfactory, and of course, he is in the pink of health, i.e. physically. I mean, he's able to take on and continue the job. And these are two of the basic requirements for re-employment. So however, in situations where example, we're assuming now it's prior to July 2022, it's to this month, for example, if you are not re-employed, you can actually file a complaint to Ministry of Manpower if you're not re-employed. And However, the company does have a recourse. The company can actually give, if they are unable to re-employ you for a variety of reasons, they can actually pay you what we call an employment assistance payout or employment assistance payment. There's a formula for it. There's a max amount that they can pay you so that, to compensate not re-employing you. So that's the way out for employers who are unable to re-employ their workers.
And this only happens after the 1st of July.
No, it's already in force.
Okay.
It's just that 1st of July, the re-employment age has been raised to 68. And therefore, and the retirement age is raised to 63.
Okay, thank you
62,
very much.
63, the retirement ages are mandatory, it's statutory provided. The re-employment age, there's this EAP, as I alluded to, employment assistance payout, which will help employees who are not re-employed.
So Patrick, any schemes to support employers of seniors? Yes,
in fact, there are quite a number of schemes to support mature employees. As we heard from the recent budget announcements, there's SG United traineeships and skills programs to help companies or encourage companies or encourage mature employees to take on skills and some of these jobs at the mid-career level. Over and above that, there's something called the Jobs Growth Incentive, JGI for short, which has been extended from which is supposed to end in March, but just announced a month ago that it will be extended another 6 more months to September, where companies can get some form of subvention. There's a formula, depending on the age and the amount and the amount of monthly salary that you're paying, and you can actually get some subvention for salaries for your salaries of these employers, of these mature employees that you hire. So I think that's another way to incentivize more of our employers to hire more of the mature workers. And finally, there continues to be the various subventions, for example, like the special employment credit, which is still in force, and therefore that is another incentive that helps encourage employers to hire more mature and more older employees.
Thank you very much, Patrick. So before we jump into the next job seeker, let's look at a couple of questions. This question is interesting. Is a student on internship supposed to be given a pay slip to check if payment was made correctly? I am assuming it depends on the company, but pay slips are usually given. Am I wrong, Wei? Correct me if I'm wrong.
I see no reason why the person should be deprived of a pay slip for the simple reason that he's an intern. I mean, if the company, what is the company's policy, on this? Some give electronic ones. Some have a system to which you can log in and you can check, or you could even download a copy. I do not think that, if everybody else is getting a pay slip, I think the intern is entitled to check with HR if he could please have one as well.
Yeah. Also to see whether the intern is entitled to some form of pay. Pay is a very big word. It can mean the salary, but usually interns will receive sort of like a stipend or allowance. So it very much depends on the nature of the internship or attachment. So if any of you are students, who in any of our institutes of higher learning, you can check your school, check your student affairs office, as well as MOE does have some best practices or procedures for internships rolled out by institutes of higher learning. However, if you are a trainee or intern under the SG United traineeships program, for example, or some of the mid-career professional conversion programs, for example, there are actually some terms and conditions that are provided in the traineeships, the SG United traineeships, as well as the professional conversion programs. And that comes with it some form of stipend, allowance, training allowance, as well as other form allowances. And some companies, quite progressive, they actually top up the allowances. So it depends. Yeah.
Okay. Next question is really great, actually. Employees are often not covered, employees are not often covered under insurance for mental health medical treatment, such as outpatient psychiatric intervention for burnout, depression, and anxiety. But I think nowadays a lot of companies are looking into that, mine specifically. Should employers provide better insurance protection for employees, especially for sectors like social service and healthcare? Maybe the question is more of what more prone to staff having burnout. So should employers be looking into this, Patrick?
If you ask me, I said yes. My short answer is yes.
And are they looking into it?
I also noticed, I actually, because of this past 2 years and me seeing more cases of mental distress and overall mental health challenges, I've actually spoken to quite a few insurance companies. I think many of the challenge here is not all insurance companies are quite into this providing or underwriting this particular space yet. So it's not very pervasive yet. Some do. So some insurance do provide for this space. And I know some companies, the more progressive ones, actually provide as a staff benefit or as sort of like a workplace safety and health benefit to allow you to tap on, for example, flexi benefits or some medical benefits or health claims to see a psychiatrist or to seek counseling help, etc. So it depends, but like I said, it's not pervasive yet. But if my short answer as I started off is yes, I totally agree with you that we should provide for this and moving forward.
I really hope more employers would take this into consideration. So let's go into our next job seeker, Bruce. Now, this is very interesting. Bruce is a graphic designer. And if you know, a lot of people in the arts industry and a lot of industries have been freelancing. So being a freelancer is, the last few years, I think it's really helped. The industry has grown. So as a freelancer, Bruce is earning 4,000 to 5,000 a month. Great salary, right? So Bruce now recently was offered a full-time job as an in-house graphic designer with an advertising firm. Of course, Bruce enjoys being a freelancer, own time, own target, and you can easily earn 4,000 to 5,000. And he doesn't only have to freelance as a graphic designer. He could be doing a couple other things. He's not tied down to one company. So Bruce now is not sure whether he should continue being a freelancer or being fully employed. I won't say gainfully, but fully employed. So this is quite tricky, right? Being your own boss and being bossed around in short. So Patrick, what are the differences in the rights or privileges between being a freelancer and being fully employed?
Yeah, I think this is a very important question. I know, as we are talking today, there are around about 200,000 in Singapore who are on freelance and self-employed arrangements, various sectors. You have your private hire vehicle drivers, you have food delivery champions, you have your artists, you have people in the creative sector, you have insurance agents, property agents. So there are actually about 200,000 of them. But I think there are a few important legal and non-legal questions you need to ask yourself. Of course, firstly, it's a freelancer. If I may use some legal jargon, it's now is a contract for service arrangement, vis-a-vis an employment relationship as a contract of service. So what does that mean? When it's a contract for service, it's a freelancing arrangements, you do not get any of the employment rights which we have been sharing in the last hour or so. Particularly all the statutory provisions in the Employment Act do not apply to you, and even some of the things that I've shared about, even in collective agreements, etc. So they do not apply to you. So that's the unfortunate bit of it. However, that said and done, it's very much a personal choice and decision, because I know I speak to many freelancers and freelance professionals. They actually want to do freelancing for the very, very reason that they want flexibility, they want autonomy, they want control of their time and the things they do. However, as a word of caution, being for the labor movement, and why we sometimes encourage some of the more vulnerable freelancers to really go on a full-time position, is because of a few reasons. Firstly, of course, we worry about retirement adequacy, because as a freelancer, you don't get your CPF contribution from your employer. Yeah,
Yes.
so that's a fact, because a lot of us use our CPF for housing, education, health, and other arrangements. So, but however, if you are a freelancer who's drawing a decent amount of benefits or decent amount of salary or payments, do contribute to CPF to grow your nest egg. So that's one. Second one, work injury compensation, something which we are quite worried about, because in the contract for service of freelancers, they do not have, they're not governed by the WICA, Work Injury Compensation Act, which actually requires employers to provide some form of workman compensation in the event of an injury in the course of work. So that's a statutory instrument, statutorily provided for workers in an employment relationship. So you do not have that. So these two are things that we are quite concerned about. Of course, if you do get into a dispute.
Yes, I was just going to ask, what happens if
dispute? TADM fortunately has provided extended their services to freelancers, but it's again on a voluntary basis. So if the buyer of your service and you have a dispute, then therefore it's useful mechanism which you can tap on. However, Employment Claims Tribunal do not hear claims by freelancers. You actually have to go to the Small Claims Tribunal, which can hear your claim if there's non-payment by your buyer.
Okay, and where is there a limit for the small claims? Is there an amount that one can go into?
If I'm not wrong, it's 15,000, and with agreement, it is with parties agreement, it is 20,000 if I'm not wrong.
I think I remember that amount.
Sorry, it's 20 now. It's gone up to 20 and 30 if there's consent.
Yeah. So it's very much like the Employment Claims Tribunal now.
Yeah.
Because revision, it was previously the amounts you stated. I think they just revised it to align with the Employment Claims Tribunal as well.
Yeah. So same thing. No legal representation at the Small Claims Tribunal. But I think if I'm not wrong, it doesn't have such sophisticated processes like a mediation and whatnot that's attached to the Small Claims Tribunal procedure. Personally, I think in the course of my work, I see that a lot of employees actually utilize the Employment Claims Tribunal as a first recourse. I know this because, sometimes our clients who are employers, they are met with these claims. So I think it's a very, very useful option for those who are full-time employees. So I think there's actually a lot of value in that, which freelancers may not necessarily have.
Okay, I have a question for you, Wei Yi. Someone's asked, as a freelancer, do they have to register with ACRA as a sole prop?
No, they don't have to. They do not have to do that. I mean, this is it's a matter of how you prefer to run your business. You can just simply be an individual providing your services, and you sign your contract with whoever is buying your services as an individual. There is no need for this registration.
Okay.
Yeah. The only instances I know, the buyer of your services wants you to have a company or business. Some business they want a real business or company to transact with. So therefore, in some instances, people actually set up businesses or register a business or set up company for this sole purpose that they want to get some form of contracts on certain category of buyers. But otherwise, individually, you can actually, that's like many of our food delivery champions, they are actually, individuals providing their service for fee.
I think for freelancers, LSPBS and NTUC has done some great webinars in the past year. So do visit the LSPBS's YouTube and you can catch some of our great webinars over there. Next question is also for Wei Yi. Does the company have a right to ask for the submission of scanned copies of IC prior to the first interview?
Well, prior to for what reason?
I'm also wondering what reason would you ask for a person's IC?
Are they concerned about impersonation? Okay, that's no right Okay, there's no right to do so. Like I said, if you are a potential employer or employee attending an interview, there's no right for the company to insist on it. If you do not wish to provide it, then you can decline to. I mean, of course, it is also for companies to decide what is the criteria for admitting you into the first interview. So, I mean, the unfortunate outcome may be that if you don't provide it, then, you know, the company may decide that they would not even give you the opportunity for the interview.
Yeah, you're absolutely right. I think even pursuant to the Personal Data Protection Act, yes, you don't have to produce an NRIC, but however, in some instances where you need to verify, there's exceptions in the Act that says, if you need to verify, for example, in case this person is impersonating another person, or, to verify even documents like educational qualifications or even skills qualifications, they may require you to produce it to verify that maybe you're physically in Singapore, you're Singaporean, and however, I think it's good practice, even as prescribed by the Personal Data Protection Act and its guidelines, to destroy those documents if subsequently he or she is not being hired. So if you do know of prospective employers who abuse your identity documents, then feel free to make a complaint to the PDPC.
Yeah, I think it's always good to ask why you need a copy. And this is not even signing on the contract. I think it's not even before the first interview. I have a next question, which I think it's very interesting. Someone has a friend who's recently resigned to join another company as an industrial designer, only to find that he was told that he's not allowed to work in the same industry because of the restraint of trade clause. So Wei Yi, could you walk us through about the restraint of trade clause and what is it about and what to do when someone sees it in the contract before they sign?
Okay, I laugh because it is actually a slightly more complicated area in law. Yeah, and actually there's a lot of litigation that revolves around it. Okay, restraint of trade clause. Very often, they are unenforceable in court. Okay, so which means that if an employer tries to enforce the clause and sue the former employee for a breach of this clause, the court may then pronounce that this clause is not enforceable and therefore the employer cannot succeed in the claim. I would like to caveat this, like what I said about defamation. There is a practical problem that some employers will try, okay, and until it is adjudicated upon by the court, the former employee is dragged through the entire legal proceedings. But it is not always, I want to clarify, it is not always that these clauses are not enforceable. Okay, it's basically whether the court will consider whether or not this clause is a reasonable clause and whether it is actually put in the employment contract to protect an interest of the company, a legitimate interest of the company. So for example, okay, if you are a very high level employee who is like, in charge of marketing for the region, okay, and you leave and there is a restraint of trade clause that says that for the next 6 months or next 3 months, I'll just take 3 months. For the next 3 months, you cannot join a direct competitor. Okay, then it may possibly be considered to be a reasonable one because this person has the potential to cause great harm to his former employer by, for example, simply poaching all the customers of the former employer.
I've heard of it, yes.
Yeah, so you see the question. So I think what the court considers is, what you're trying to restrain. Does this person really have the ability to ruin your business, to compromise your business? And the other things that you look for are things like time period. How long is this restraint of trade clause? 2 years is considered very long.
Yeah.
Okay, a couple of months might be more acceptable. And then geographical extent. Are you saying that this person cannot work in this industry in the whole of Singapore? Or maybe, if you're talking about like a nail salon, maybe you could say that this person cannot work, within in an area of maybe about 10 km radius from the former employer's outlet. Because for a very simple reason, you might end up poaching the customers who are living nearby, right? So these are all very practical considerations, and none of these factors are on a standalone will enable the court to determine whether or not a clause is reasonable. it is a consideration of all these factors in totality. So for example, if this industrial designer, is it?
Yes.
I mean, look, if he's just a member of the team, fairly junior, and he decides to leave and join another company, then I mean, it is unlikely that this person is going to be able to really cause substantial detriment to his former employer. And then particularly if you're saying a restraint of trade clause, which is a year long, he cannot join any other company that's in the industry. I think that's considered unreasonable, because you see, industry can be very wide. Companies within the same industry may not necessarily be direct competitors. So for example, like large scale companies may go for large clients, like multinational clients. Some smaller companies may go for only local clients, like advertising companies. You might target local, smaller scale, more modest clientele. So these are not direct competitors, even though they are in the same industry. So if the clause says that you simply cannot work for anybody in the industry, as opposed to one that says you cannot work for somebody who is a direct competitor, somebody directly competing for the same customers, the latter would be more reasonable and the former will be quite unreasonable. So yeah, so for somebody who sees a restraint of trade clause in the contract, I would say, truthfully, they should try to have it removed, because having it in there means that the employer can actually sue on the clause. I mean, whether he succeeds or not is a different question, but having it in there enables the employer to sue on the clause. So I understand also sometimes it's very difficult. You may not have that bargaining position to say, I want it removed. Perhaps you can consider speaking with your employer whether or not you could modify the clause. Shorter period, maybe confine it to certain competitors. The other thing is also, at the point in time when you leave the company, sometimes it helps to have an open conversation with your former employer to let them know who you are joining. I'm joining this company. It serves a different set of clientele, even though I'm utilizing my skills as an industrial designer. Can we come to an amicable arrangement that you will be fine with me joining this other employer? And important, have it in writing. So send an email. If the company does agree that, look, okay, fine, it's fine, you just join this company. Have it in writing, have it in email. These are ways to I would say, solve the problem. Yeah, if you already have that restraint of trade clause in your contract, or you can't get it removed.
Very helpful. Patrick, anything to add on this before we wrap up?
No, I think we covered most of the points. Just one final point to augment on contract restraint of trade. It will be usually these clauses are imposed on more high-level positions, people with a lot of confidential information, customer lists, and so my take, well, haven't tested in court yet, is that it will likely be unenforceable against lower level employees, particularly the blue-collar employees, as well as low-wage sectors kind of employees. Because I've been asked this question on a few occasions. In fact, I know of some lower wage workers, for example, like private security officers, who actually receive a contract, and then I suspect the employer probably cut and paste that employment contract from somewhere, which has a restraint of trade clause. You can imagine a security officer, private security officer on the ground, could be just earning $1,500, $1,800 a month, and then you're telling him, if you will leave us, you can't work in this trade for the next, I don't even have to say 3 months, some put 6 months, 1 year, some say, within a 10-kilometer radius, which is quite absurd, because if you're talking about lower wage employees, I mean, what can you expect them to do, But for example, like private security officers, many of them are working in particular sites, location on this particular building, and if that particular company, private security agency that hires them lost the contract, it's more than likely the new security company that has gotten the contract will hire that same person, because it's of familiarity with the employees there, the ground situation, etc. So I think it's quite unconscionable to impose such restraint of trade clauses on the rank and file and lower wage workers.
Thank you very much. And I'm so sorry about the dog. We must bring this webinar to a close. I want to thank everybody for sending your questions. And I'm so sorry if you didn't get to it. So Patrick Tay, thank you for sharing your experiences and your time with us. Your first job, participants, your first job, whether it's part-time, full-time, internship, is important for so many reasons because it determines your career trajectory, right? Your first job sort of shapes your outlook in that way. So it can set you up for success if everything goes well, or it can give you a really slow start for some reason if it doesn't work. And there's nothing wrong if it doesn't work, because you always get back on the bicycle and you cycle again. So knowing the different aspects to consider in your first job allows you to make a better decision in which opportunities to take. Always read your contract, always ask that questions. And I think whatever Patrick and Wei has shared today is so important, because all of us will always be going to a new job because we want to look at greener pastures. It's always good to ask all these questions. So if you're facing an employment issue, and if you're an NTUC member and keen to register for a legal clinic, you may write to LawWorks at ntuc.org.sg, and LSPBS has put on all the links to the resources and to the forms and everything in the chat. So please do not forget to download the resources and click on the link. After this webinar ends, which we went over by 5 minutes because of such a great conversation, thank you both, a feedback form will be shown in your browser for your completion. And we really appreciate if you could just take a couple of minutes, fill up the form of how we can improve the webinars, what more we can do for you. Now, with that, I am Regana, your moderator for today. Once again, Patrick and Wei, thank you so much for spending your time with us. On behalf of Law Society Pro Bono Services and NTUC, thank you very much for joining us today, and have a pleasant week ahead. Bye-bye, everyone.
Hi, everyone. Take care.
Bye. Take care.